Hello and welcome to this week's episode of Chaile Time. Toby, welcome.
Thank you, Chepo. Morning, welcome to you. I'm very well.
Good, thanks. So what have you been up to? Last week I didn't join you because...
Last week you were ill or something?
Not really. You see, I had a runny nose, so I can't keep on saying every time you see. So I had to let you do it alone. So how are you doing? How you've been? What is that you've been up to?
Well, besides the CCMA issues, in a way the last couple of months, but more specifically the last couple of weeks, we've been dealing with compliance issues. Employers who are not complying with labor legislation. Or not only labor legislation, also the Immigration Act. You know, employers don't know about that act. The one that says...
Who said they don't know?
And that's a very good point you're making, because when I talked to them, I had a meeting last night with a client. He actually took us out for dinner. And when we spoke about foreign nationals,
yes,
his paperwork is in order. All the passports, all the work permits, he doesn't have any issue whatsoever. So I said, do you even know what you're looking at? They all have their asylums, like, asylums. Since when is the South African government giving out asylums these days? Is there war in Southern Africa? These things are fake. In terms of the Immigration Act, what act? The Immigration Act. You as an employer must verify that that permit is legal, is legitimate. Did you, Mr., verify those documents? No. He just accepted on a face value that, that permit is what it is. And then eventually I told him, just think logically now. What permit do they have anywhere besides an asylum? Okay. Now I understand the ZEP and the LEPs and those kind of things for the Lesotho exemption permit and the Zimbabwe exemption permit. But what about the Mozambicans and all these other people coming from other countries? What permits do they have? Now it says work permits. Now, do you really think the law is going to allow us getting cleaners and waiters and bartenders from other countries to come and work here? Maybe if you're a doctor or engineer or something like that, yes.
Is it a special skill?
You know, but employers, they just can't think of these things. It is just amazing. They just like...
But remember...
Then I have to tell them, okay, you go to America to go be a supermarket cashier. Do you think they're going to allow you? Just think logically now.
But this is what I always say. From day one, whenever I'm doing an introduction to whether it's public or new client, I always say, employers focus on the zeros. Then
because you know what the answer to me was?
Yes.
Yeah, but the foreigners work harder than the South
Thank you very
Africans.
much. You see?
Yeah, but that doesn't stand in the Immigration Act. You can, you need to verify foreign national permits unless if they work harder, then you can just accept them. There's nothing like that in the Immigration Act. A sub-clause that says if you work harder, then you don't have to.
Then there's an exception.
There's an exception. There's nothing like that. But anyway, today I want to talk. Look, we're going to talk about compliance issues today. I think the topic of illegal foreign nationals was just like the introduction.
Yes.
That's actually not what I want to talk about today. I want to talk about basic compliance with the basic conditions of Employment Act, UIF, you know, minimum wages, those kind of things. And it is so interesting now how often you will talk to companies about minimum wages, being compliant. You know, industries where the businesses are falling under a bargaining council, you know, even our clients.
Yes.
I'll tell them, let's talk the main agreement. Let's go through it. This is what you're supposed to be doing. And it falls on deaf ears.
Every time.
99% of the time.
Every time.
But you know what? Every now and then, especially now, guys, listen, the Department of Labor, they are out. They are out in the streets. They are knocking on doors. Every now and then I get a phone call. Jimmy, come see me, come see me. And then there's the compliance order.
You know what's happening?
Expensive.
You know what's happening? We're living in a GNU era now. And with the,
GNU.
because with the GNU,
What is it, Steenhuisen?
with the GNU, I've noticed something since the start of the GNU thing now. Everyone wants to prove a point.
I think GNU said, listen, government needs money. Easily. Go knock on the doors of the employers. You're going to find lots of non-compliance there. So anyway, this company, they're actually not a client of ours. They're now on an ad hoc. We're helping. They're actually coming on the retainers. I believe I've got the word yesterday.
Okay.
So we can... I don't know what to say actually. Because, you know, it's interesting. We gave them a quotation to help them become compliant from a payroll perspective, if you want to call it that way. And then we give them a quotation so we can also service them from a dispute resolution perspective moving forward. In other words, fighting the CCMA battles, because the Department of Labour is now threatening to sue the CCMA and whatever the case may be. Okay. But interesting is they approved the service level agreement for the dispute resolution part, but not the payroll part. They will take care of that themselves. Crap, man, I haven't taken care of that for many years now. So you know what it tells me? I can be wrong, but it tells me that, we're in trouble now. Let's become compliant now, but then we will take care of the Department of Labour at the CCMA. We're going to fight the battles, then they don't have to be compliant anymore.
Please repeat that again.
You see, the thing is this. Payroll forms the basis of legal compliance.
Yeah.
In terms of the BCA now, as an example, how much overtime must you pay?
Sunday time.
And your leave payments, your public holidays. A lot of the provisions in the Basic Condition of Employment Act is actually coming down back to your payroll system. Whether you do payroll to start off with, your UIF deductions, your PAYE, which is your employee tax. Okay? The foundation of all of that is your payroll system. So to a large extent, legal compliance is based on your payroll system. And if you look at this first compliance order they got, okay, it's about, okay guys, you've got these employees working here, where's the contracts? There's no contracts. Okay, so now they need to submit contracts. So we help them drafting the contract. Show us the attendance registers of the staff for the last couple of years. Can't show it. Let's make pay slips for the last couple of years. They don't have pay slips. So we've helped them now with pay slips. But now these are payroll functions. But now what's interesting is there's two elements to compliance here. The one is being compliant in terms of your payroll, your UIF deductions, your STL, your quota, your PAYE. Make sure the time and attendance is up to date. Making sure the correct hours being claimed on your payroll system, overtime, public holidays, leave pays, and all these kind of things, okay? Then the second element is if you're in trouble, the fights at the CCMA, maybe even the Labour Court. Now it's interesting, we assisted this company now to become compliant from a payroll perspective. So we got our payroll manager involved, and we're now we've done the UIF submissions, we're doing the back pays. They need to pay penalties, by the way. We've given staff contracts now, we've done the pay slips for the last couple of years. So from a payroll perspective, they're becoming compliant now. But now remember, it's only ad hoc, so we're only helping them to become compliant with this compliance order.
And then they say...
Now the question is, what about the future?
They're going to take it from there, remember?
Now our payroll quotation to them, man, it's cheap, man. 2,500 Rand for 20 staff, full payroll function. Serious? They say no, they'll do it themselves. They don't even have a payroll function. There is no payroll in their company. You know how they pay staff? Every week, cash. There's no pay slips, nothing. It's here like this. So now what does it tell me? If they accept our retainer for fighting the battles in the courts, but not being compliant to start off with. Moving forward now, I'm not talking about now this isolated instance of becoming compliant for historical issues. They don't want our services for making sure the UIF is paid for the next 10 years. So PAYE. All these things that the staff attendance registers is up to date. That we mustn't touch that.
There's going to be issues here because now you handle the issues temporarily. And because now they are on a retainer this side, you have to fight these issues in future.
Yeah, you see, this is the thing. These are people who probably don't have the intention to be compliant over the long run. They're in trouble now, we need to fix now. But yeah, they do need some help if I'm shit in the future, you see. So that's why they think, let's just, but okay, we'll climb the bridge when we get there. But anyway, so that's now the first compliant order. These guys are so scared of the CCMA because the inspector is threatening to sue them now at the CCMA. Look, we did miss the deadline was like 2 days or something. And the reason being is because, obviously there's a lot of contracts that must go out and they must get all the staff to sign it. So it took about extra 2 days for them to get all the signed contracts back to us. So, but look, all the submissions were made and confirmation was done that it was done accurately. But now the inspector is like difficult to say, I'm still going to sue you. You missed your deadline. I'm going to sue you at the CCMA. Whether he's going to do it or not, I don't actually think so. You just want to prove a point, I suppose. But now, when the inspector sent an email, now I got word that the HR manager, they went to the church, and now the church is now praying that we don't go to CCMA. And you know what, I'm trying to tell them, look, probably we're not even going to go to the CCMA, but even if it is, it's a non-issue at this point, because, what are they going to say? We must comply with ABC, and we already did so. Yes, there is the fine, but that's not the issue. They will pay the fine. The first fine for compliance orders is 3,600 rand, so it's nothing. But now they're asking, okay, so are we done now? They said, I don't know. There can be many compliance orders. So now they've got compliance order number 2. Okay, national minimum wage. So current national minimum wage is 27 rand 58 cents an hour.
How much they were paying?
12 rand an hour. For many years now. Okay, so now that one with penalties is 400,000 rand. The church is now not just praying, they're fasting.
40 days, 40 nights.
And we've worked out now, you know what now? This staff, some of them are illegal foreigners. They don't have bank accounts. Now their phone is, okay, so that means I need to back pay one guy 27,000 rand cash under the table like this. So just make sure he signs a receipt that he received it, because that's the proof to the department. You see, if you venture in the space of non-compliance, then the staff can't even get bank accounts because many of them are illegally in the country. I don't even get bank accounts. So now you resort to paying cash under the table and all these kind of things, you see. So now the second compliance order is with the penalties close to 400,000 rand. Oh man, it is tears, So we're actually at the space now where they actually said, okay, they're going to pay this. So they're actually going to back pay all the staff for a couple of years now, okay? And pay the penalties. And now they ask me, are we done now? So I said, I don't know. Because I can think, okay, so they've got the attendance registers of the staff now, contracts, payslips. What if this inspector is in a bad mood and he says, let's check overtime payments and Sunday payments and public holiday payments for the last couple of years. So I can think of a few compliance orders that may still come. What if SARS is getting on board? Maybe the PAYEs wasn't paid. Now, look, you don't want SARS on your back. Okay. And then there's UIF. Okay, they've made some payments and whatever, But what if they've made the payments correctly? What if the Department of Labor now double check to see that whatever money they've paid over the last couple of years is actually correctly? So there are so many compliance orders that can still come. But when you... what I didn't tell you. Actually close him down for non-compliance to health and safety. So we got our partners from the our health and safety department also on board there. So they getting them up to speed now there. But when you tell them that companies like this at first, listen, you need to be compliant. No, man, don't worry, we've got this under control.
So what I'm getting here is, you can get away with so many things for so many years. But once it catches up with you, then you're going to feel the pain after those many years.
The meeting I had last night, this company in one of the divisions, they're like a labor broker in the retail space. They've got quite a lot of staff there. But their client refused to pay overtime. And they work a lot of overtime, the staff. And it's been like 3 years now that they took away the overtime policy. And when I say took away the overtime policy, not that you don't work overtime, you work overtime. They work a lot of overtime. But the payment of overtime. So the client just said, we don't pay. Staff will work overtime, but we're not going to pay them anymore. It's just blunt. It's blunt.
Basic thing.
It's blunt like that. So yes, there are agreements in place that should there be a comeback, then the client will be held liable for the monies and the penalties, whatever the case may be. And that's the understanding. So, but then last night, and then my client said, yeah, but always when somebody goes to the CCMA to complain about this money, that money, then his client pays. So it's not an issue. So I said, yeah, but up to this point, you have one staff and you're complaining about the 2,000 rand you owe him. What if there's a class action of most of the staff complaining about the last 3 years? That's hundreds of thousands of rands. He's not going to pay. And who's the employer? You. You're going to, by law, have to pay back to all the staff hundreds of thousands of rands. And you know what? Yes, you can email your client, please pay the $1 million. He's not going to. He's going to say it's your problem. And then you're going to sue him, and it's going to be an ugly lawsuit between the two of you. Okay? Maybe he will lose, not my client, maybe his client will. I can't comment on that because this is not a contractual stipulation. This is just like based on an email, or a verbal understanding. But I can just say there's a difference between paying 2,000 rand and $1 million.
Yeah.
And your friend will not be your friend anymore when it's $1 million. That understanding will suddenly be questioned if it's $1 million. That's a kind of a risk people are exposing themselves to. But anyway, so for those who are your HR managers, or operations managers, or executives, or senior managers, just explain to you how legal compliance in a nutshell works, just to give you some framework, okay? So in essence, a long time ago, or in its nature, at the heart of it, I suppose, the labor market is a free market system. In other words, in its foundation, it's a free market system. That means an employer got a job at a certain pay, at certain terms and conditions of employment. And it's up to the employee to accept it or not. There's no regulation. Nobody tells you. There's no such thing as leave and whatever. And I believe you get a lot of that still in America, for instance. It's an at-will employment relationship. I believe there you don't get paid leave and these kind of things, So at its foundation, we're talking about a free market system. The terms and conditions and the pay is whatever the parties agree to. That's at its foundation. But over time and decades, and here we need to thank the union movement. If you really think about this, okay, even though employers often don't like unions, but even like myself, I'm an employer, but I've been an employee for many years. So I've reaped the benefits of the negotiations between unions and employers. And here we talk things like all the goodies in legislation, like the Basic Conditions of Employment Act. Annual leave, we take it for granted. Annual leave didn't come just automatically. No employer sat there and think, I'm going to give my staff paid leave. No employer works. Capitalists don't work that way. Capitalists work, you work. And if you are late 10 minutes, you're fired. That's the free market system. Yeah. Technically, if your contract of employment say you start at 8 o'clock and you start at 8:01, you are in breach of contract and your employer can tell you are fired. That's the raw free market system. Fortunately, thank you, trade union movement, there are building blocks now on this foundation. So you get legislation. For instance, let's start off with national minimum wage, because that came into existence in 2019. So before 2019, there was no national minimum wage. So in industries that was unregulated, you could still have paid whatever the parties agreed to. So if I want to pay you in apples and you say yes, well, great.
750 per hour.
750 an hour. Like for instance, the entertainment industry. Yes. Entertainment industry had a bargaining council and they closed last long time ago. I think around about 2005 or so. So in entertainment, I'm talking about cinemas here, there was no minimum wage. In our days, when we were at cinema, there was no minimum wage. They could have literally paid you whatever they wanted to pay you. And that is not after the bargaining council closed down, because there would have been a main agreement. But we were employed at that time when there was no more regulation. But luckily in 2019, there's now the second building block is the national minimum wage. So no company in South Africa can pay you below the national minimum wage. And currently that is 27.58 rand an hour. Okay. There are other building blocks too, like the legislation, like the Basic Conditions of Employment Act. And that regulates terms and conditions of employment in the workspace. Here we talk about normal hours of work, overtime, we talk about Sundays, public holidays, all the different kinds of leave, annual leave, maternity leave, family responsibility leave, parental. We're also talking about averaging hours of work, for instance. So all the T's and C's of employment is now regulated by the Basic Conditions of Employment Act. Other legislation like the Labour Relations Act, it deals with matters like dispute resolution, fair or unfair labor practices, organizational rights, freedom of association, what happens if a business transfer or sell or merge to another business or so. It facilitates all those processes. So a lot of the disputes at the CCMA found its legal mandate from the Labour Relations Act and the Code of Good Practice, Other laws, the Health and Safety Act, Employment Equity Act, BEE, all these are now building blocks on top of the foundation. And then certain industries, they have bargaining councils, like, we deal a lot with the Restaurant Bargaining Council, the Metal, it's MEIBC, Metal Engineering Industries Bargaining Council, the Roadfront Industries Bargaining Council. Those are the three ones we operate in that space a lot. But there are many others also, like MIPCO and the Tea Room here in Pretoria and so. But now these bargaining councils, they've got main agreements. These are agreements that are concluded between employers and the unions. And it's normally valid for periods like the basis of the main agreement is what it is. But it gets amended like every 2-3 years or so, mostly in terms of minimum wages and benefits and so. The heart of the main agreement normally stays indefinitely, okay? But the benefits gets amended, renegotiated like every 2-3 years or so. And then there are certain industries where there is no bargaining council, but you may find a sectoral determination, like for instance, the cleaning industry, the hospitality, wholesale and retail, for instance. Now, the sectoral determination is a determination that the Minister of Labour will make from time to time, where he or she will speak into an industry and say, listen, this is the minimum wages in that industry. But most of the T's and C's of the sectoral determination is aligned with the Basic Conditions of Employment Act. So they typically deals with minimum wages. But I must say, since 2019, with the advent of the national minimum wage, sectoral determination minimum wage are mostly aligned with the national minimum wage. But you must still check it out, okay? So if you are an HR or own a business or manage a business, from a legal compliance perspective, it is not just what you feel in your heart what is fair. Okay? You need to go check out the industry that you operate. What are the regulations in your industries? If you're in a bargaining council territory, if not, do you only comply with national minimum wages? The terms and conditions, is there a main agreement or do you fall back on the basic conditions? Now remember, the basic conditions is the basic conditions of employment in South Africa. Your main agreement in terms of a bargaining council resolution may create provisions that are enhanced conditions over and above to that required by the basic conditions. As an example, the basic conditions say, for instance, if you retrench somebody, the severance pay is 1 year for every completed year of service. MIPCO main agreement's got the tiered approach. 1 year, it's one week for 1 year, 2 weeks for 2 years, 3 weeks for 3 years. You see, so it doesn't go under the minimum requirement, but it creates enhanced. Yes. In the restaurant industry, for instance, annual leave starts at 21 consecutive days, which is the BCA. But from there, every 5 years, I believe, if you work for 5 years and so, in those increments, your annual leave gets increased. You see, so You need to check out if you fall under the scope of a bargaining council. There are main agreements, restaurant, there are a provident fund, there's a funeral cover. You know, there are all these benefits. So companies need to be aware of this and make sure you're legally compliant. At the end of the day, if you're going to run away with these things, Seppo, we have companies in the road freight industries, logistics.
Yes.
These guys are running away, eh? and you know what? You know what is the Achilles heel here? These compliance orders.
Yes.
Some are dated back from day one you operated.
Yeah.
It's not just today for yesterday. No, it's now for the last 15 years, you see. I've seen some of those orders at millions, man.
It's a lot of money. I've seen some of them.
So if if you live by the sword, you're going to die by the sword. A very wise man one day said that. Go figure out who said that. And that's true. You're going to run away until you can't anymore now.
But another thing that is nice is that if you are too busy, you are held up in making those zeros and stuff, we are here, you see. You can contact us so that we can help you to be compliant.
Yeah,
because
we do payroll, health and safety.
You understand? So,
we can
if you are too busy, then in order for you to read the main agreements and compliance orders and everything.
Seppo, you can only take an ass to the water. You can't force me to drink, man.
Thanks for watching. Thanks for watching. Don't forget to like and subscribe. We'll see you next time. Bye.